Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you very much. Mr. Smith, before lunch, we were looking at those two letters and the final one that essentially put the burden onto the defendant to provide a revised defence statement. Can we now look at poll 000599425? And this is the response from the defendant's solicitors on the 4th of December 2012. And they say, we write further to your letter of the 20th of November, and thank you for the enclosures. With regard to the other matters of disclosure contained within our defence case statement, we make reference to an order made by His Honour Judge Rose at the plea and case management hearing. We are not aware of any such order that a revised defence case statement should be served with a view to disclosure being reviewed on your part. Just pausing there, I mean, it is right that there was no specific order for a revised defence statement, isn't it?
I'm not aware of any order having been made. The documentation we looked at this morning suggested that the judge had said that the ball was in the defendant's court, which is not quite the same as an order being made, is it?
It's not the same as an order being made,
no.
No. They then say, our defence case statement not only details our defence and the issues we take with the Horizon software, but we feel it explains why we make the disclosure requests. In the interest of progressing the matter, we ask that you review your disclosure obligations if you have not already done so and revert back to us with your final position. And if you still feel that you're not obliged or willing to provide the information, then we may give thought to a Section 8 application. So they are chasing disclosure once again in this letter, aren't they?
It would appear so, yes.
Poll 001078555. We're now in January 2013. So another month has passed. I write further to my letter of the 4th of December, in the absence of a response, and with the trial date imminent, I think it prudent to deal with the following matters and would be obliged for a response as soon as is practically possible. And if we scroll down and over the page, please. They say there, finally, at this stage, I raise once again the disclosure requests made at paragraph 11 of the defence case statement. As you will recall, I asked for your final position in my letter of the 4th of December 2012. I made it clear that if such material is not served, then a Section 8 application would be sought. However, perhaps before reverting back to me, it may be prudent for counsel to liaise with each other as soon as is practically possible for the sake of convenience. He gives counsel's details and then says, suffice to say, in light of our defence, the material requested at paragraph 11 is clearly disclosable under your statutory duty. If we please could turn to poll 000595557. We have an email from yourself to Rachel Panther, and it says, I've received a letter from the defendant's solicitors, and it mentions Gareth Jenkins' statement, and then it says as follows. It says, there is a chance it could go off. However, as the defendant's solicitors are grumbling about disclosure and the lack of information on the disc prepared for them by Stephen Bradshaw, they have asked the court to list the case for an intervention hearing, and the provisional date for that is the 5th of February. Do you think grumbling is a fair description of their repeated requests for disclosure?
No, I don't.
Because, of course, it had been the post office that was taking a decision to effectively delay disclosure until they had provided more particulars.
Yes, I can't recall precisely the sequence of events, but I am under the impression that Cartwright King, either through myself or Rachel Panter, liaised with Stephen Bradshaw on a number of occasions. I just can't remember, I'm afraid, without looking at the file, all of those occasions. But certainly, yes, they were, quite frankly, right to complain, weren't they?
Yes, and not just in respect of any delays on Mr. Bradshaw's part, but we know that by this time you had received the database, although your evidence is you didn't open it.
I hadn't looked at that, no.
You had received a note by Helen Rose. Again, your evidence is you hadn't opened it.
I hadn't looked at that, no.
You were aware of a similar case going on at the time where you say that involved information about a bug. You were also aware of Second Sight investigating at this time. Was there a lack of curiosity on your part in respect of the various requests that they had been making?
And I don't think there was a lack of curiosity. I think I took the view that the requests were for, or some of the requests were either too wide or information that wasn't relevant or not going to meet the test for disclosure.
So why are you saying that grumbling isn't a fair description of what they were saying?
Well, I think it's, looking back, I think it would have been better to have rephrased that, repeating their requests for disclosure. So I also think that as a firm we were liaising with counsel as well in relation to disclosure. And so grumbling, I think, is perhaps an inappropriate term.
Doesn't it suggest a degree of ambivalence on your part?
No, it's just an inappropriate word with hindsight.
It was a word that was used because you were ambivalent in respect of their disclosure requests.
No, I was very aware that they were making repeated requests. And yeah, they'd raised this a number of times.
Can we please look at poll 0011460? At the bottom of the first page, we have an email chain still relating to the case of Ishaq. From yourself to Mr. Bradshaw and Mark Ford. If we scroll down, it says, "Dear Steve and Mark," and then we have to go over the page. "Please find attached a letter which we've received from Messrs. Musa Patels today, enclosing an addendum defence case statement. I note that the addendum defence case statement sets out the reference numbers of numerous reports which the defendant apparently made. It is the last working day before the trial, and I am somewhat suspicious that the information was not disclosed at an earlier stage. Steve, could you please go through the addendum DCS and make such inquiries as you are able to today?" Just pausing there, do you think it was right to be suspicious, given that it had been you who had been pushing them to serve particulars?
I felt that we had been ambushed. I had certainly asked for particulars, for assistance if you like, but for particulars of what they were saying at earlier stages, and this information which could have been provided at an earlier stage was provided right at the last minute. And as you recall from my evidence this morning, I said that I'd written to the defence specifically asking them if they could particularise any examples, because I did not want to be in this position where at the very last minute information was being received just shortly prior to the commencement of the trial, and obviously there was very little time then to look into it.
But couldn't you have made things quite a lot easier by disclosing concerns that had been raised with you about the Horizon system quite a long time before this email?
Well, when you say concerns, which concerns do you mean?
Well, you were prosecuting somebody for a criminal offence.
Yes.
You were aware of a number of other cases raising issues with Horizon. You were aware that an independent investigator was looking into it. You were aware of another case with very similar facts. Did you not think that maybe we should provide a little more disclosure of those kinds of issues to the defence.
So by the time of this email, I think the statement of Stephen Bradshaw, which dealt with the appointment of second sight by Post Office Limited, had already been served. And so far as other allegations that were being made in other cases were concerned, I did not consider that they met the test for disclosure.
And you say precisely that in the next paragraph. You say, I have no intention of providing details of previous cases in which there has been an unsuccessful challenge to Horizon. That information does not undermine the Crown's case or assist the defence. Now, your evidence before lunch was that you didn't even look at the table relating to unsuccessful challenges to Horizon.
Well,
so
I didn't.
How could you have reached the decision that it doesn't undermine the Crown's case or assist the defence if you hadn't actually read the document that had been sent to you?
Well, by virtue of the fact that they were unsuccessful challenges, I didn't feel that they would be disclosable.
Did you not think that it was incumbent upon yourself to at least carry out a very basic level of research into those matters?
I didn't at that stage, no. I was under the impression that it was a table of unsuccessful challenges, unfounded allegations, and in those circumstances, I did not consider it further.
Now, we've seen the defence statement. I don't need to take you to the addendum. In terms of the timeline, Mr. Ishaq pleaded guilty to theft on the 7th of March 2013, and on the 22nd of April 2013, he was sentenced to 54 weeks imprisonment. I would like to take you to an email from March 2013. Can we please look at poll 00105-209? This is an email of 26th of March, so in between Mr. Ishaq pleading guilty to theft and his sentencing hearing. And it relates to second sight reports, or so the second sight investigation. You're advising Jarnail Singh, and it's, the subject is Horizon issues urgent. And in fact, perhaps we can look at Mr. Singh's request. That's page 2, the bottom of page 2. Mr. Singh emails Andy Cash and yourself, and he says, Andy, may I have your view on this? Why the Post Office cannot simply stay and hold fire in prosecutions where there has been an alleged Horizon issue, yes or no? Can we stay something, or is it all or nothing? So Mr. Singh seems to be asking for your expertise as to whether or not all prosecutions can at that point be stayed. Is that your understanding of that email?
Well, it's one potential reading of it. Mr. Singh wasn't always that easy to understand with the way he phrased things or discussed things, but that's certainly one way of looking at it.
And what is another way of looking at it?
Just asking for general advice. Why Pol cannot simply stay, or should Pol simply stay? Yes or no? Can we stay some, or is it all or nothing? It seems to be asking for a general advice, a general view, doesn't it?
So your interpretation is he may have been neutral on the matter and was asking for your advice?
Well, it's not straightforward, is it? Why Pol cannot simply stay, that would be suggestive of the view that that was perhaps his opinion, but then his further question is, can we stay some, or is it all or nothing? So that is perhaps more open. As I say, Mr. Singh wasn't always the easiest to decipher.
And why do you think that was?
I think some of his conversations or emails were less than clear.
And why do you think that was?
Just on looking at them. I mean, looking at these two lines here.
Is it your suggestion that he had some sort of nefarious purpose or some other reason, or is it simply the language used?
I thought at the time it was the language used, but obviously as this has rolled on, I think that he perhaps knew a lot more than he was letting on.
Let's see your response on page 1.
Because if I can just say, because up to that, if you think about his earlier communications, he has been very much arguing that the Horizon system is robust, and that's very much the phrase that I placed reliance on. Then, of course, with an email like that, it makes you wonder, with hindsight, exactly what was going through his mind.
And what do you think was going through his mind?
Well, I'm wondering whether he knew that there were more things that we didn't know, and obviously he hadn't imparted that to us.
Your response is as follows: if applications were made to adjourn all existing cases until after the report becomes available, this would result in a nightmare situation. The fact that application to be made would send out the wrong message, and it would be assumed by many that the Post Office had found and was trying to resolve a problem with the Horizon system. Whilst it could be made known that no problems have been found by the Post Office, it is unlikely that defendants would believe such a statement. I would expect there to be numerous applications for disclosure and extra hearings and extra costs. So you're advising against staying cases because it would lead to more applications for disclosure.
I think this was generally the view of Cartwright King. I don't think this was my specific view. I think this had been discussed internally, and this was the firm's view.
Well, we see at paragraph 3, for example, it says the best approach, in my view,
Yes.
is to treat each case individually. So were you communicating your own views there?
Well, I believe that would have been my view after I discussed it internally.
The prosecution can commence in the usual way, and upon receipt of the defence case statement, any challenge to the integrity of the Horizon system can be considered. Of course, the first time we may get to know of a challenge may be in the defence statement. If a real issue is raised, the case could be adjourned until after the report becomes available. The defence could apply for the adjournment, and we would not object. If, however, the challenge raised in the defence statement is flawed, has no basis or foundation or relevance, and is clearly just an attempt to frustrate the prosecution, the case can continue in the usual way. It's the same approach, isn't it? Putting the burden on the defendants to raise the issue of Horizon, to raise a specific issue that satisfied some sort of test that would prompt action on the part of the Post Office, rather than being open and honest with defendants when they raise the Horizon system as a problem.
Well, I don't see it that way. I see this as taking a case-by-case approach. There were some defendants who had made full and frank admissions in interview, and there were other defendants who the Horizon system wasn't of relevance to their case.
How are you to know if it's a real issue that's being raised? What was the criteria that would be applied for that?
I don't think we set out any criteria.
How would you test if it was a real issue or not? What would the threshold be that somebody had to raise in order for the Post Office to agree to stay their case?
I don't think I considered that point.
I want to look at what happens after this, and I'm going to move to the 12th of June and the receipt of what is the Helen Rose report. That's FUJ 000868111. So the date there is the 12th of June 2013. Can you recall when you saw the Helen Rose report?
I don't believe it was it could have either been at the end of June or the beginning of July. I do recall that we were informed that the second site interim report was going to make reference to bugs. I don't think at that point we knew anything more than the fact that there were going to be references to bugs. And then I think that either at about the same time or very shortly after a meeting with Post Office's legal team on Old Street in London, the Helen Rose report surfaced. I don't think it was before that meeting. I think it was possibly either at that meeting or shortly afterwards.
So I think in your statement, paragraph 3 of your second statement, you say that on the 27th of June, you had discussions regarding the second site interim report.
Yes.
Is it at that point that you were told about the Helen Rose report, or?
No, I think the 27th of June was the date upon which I received a telephone call from someone in the Post Office legal team asking me about bugs in Horizon, and it was phrased in such a way which implied that they did not know of the bugs in Horizon. And I spoke to Mr. Singh and asked him what he knew of the bugs in Horizon, and he also told me that he did not know of the bugs in the Horizon system. So that was the start, if you like, of the second site interim report chapter. But I don't know how soon after that we received a copy of the draft interim report. I know it wasn't published until possibly around the end of the first week in July. I suspect that we may have received snippets or parts of that information beforehand.
It was early July. I'll take you to the various emails. Let's stick with the Helen Rose report. You said that somebody phoned you up from the post office.
Yes.
Do you recall who that was?
I'm afraid I don't. I don't recall who it was. I could guess, but I don't want to guess and get it wrong.
When Mr. Singh told you that he didn't know about bugs, did you question that with him?
No, because it had rather taken me by surprise as well. So it was apparent to me that, from the way that the question had been phrased, that Post Office legal team didn't know about the bugs. I was taken by surprise by reference to the bugs, and I asked Mr. Singh, and he didn't know about them either. So I just assumed that the Post Office legal team did not know about the bugs.
I'm going to very briefly take you to a couple of parts of this report. If we look at page 3, please. We'll come to look at an advice that relates to this report, but she says, for example, in relation to correspondence with Gareth Jenkins, I know you're aware of all the Horizon integrity issues, and I want to ensure that the ARQ logs are used and understood fully by our operational team. Recommendations, if we scroll down, she says, for example, however, my concerns are that we cannot clearly see what has happened on the data available to us, and this in itself may be misinterpreted when giving evidence and using the same data for prosecution. So we'll come to look at the analysis of the Helen Rose report. Before we do that, can we please look at poll 00142322? Now, this is a transcript of a conversation with Gareth Jenkins, and it's Simon Clark and also yourself are on this call. Are you aware of how this came into being?
Yes. Mr. Clark had a case called Samra that was about to start, I think, before the Crown Court at Birmingham. And he was concerned that, as a firm, we now knew of the existence of a report which we perhaps didn't have at that point, but we knew some of the content of, in that it was going to refer to bugs. And Mr. Clark was clearly concerned about whether or not that would be disclosable in the proceedings in Birmingham. And it was in those circumstances we telephoned Mr. Jenkins to try and find out some more information.
I think this is the 28th of June.
So that was probably the day after we'd been informed of the bugs.
So is that the day after the telephone call from somebody in the post office and your discussion with Jarnell Singh?
Yes.
And were you aware that the conversation was being recorded? Was it typed at the same time, or how did this come about?
I'm not sure whether I recorded it or whether I typed it.
Did you have a conversation with Simon Clarke before about the kinds of questions that you were going to be asking? We'll see that there are some very specific questions with A and B, for example. Was it something that was planned?
I don't recall discussing it with him. I'm sure he had something set out in his own mind as to what he wanted to ask.
Presumably Gareth Jenkins wasn't told that it would be recorded or noted.
No, he wasn't. He wasn't.
And it begins, "Hi, is that Gareth Jenkins?" It is indeed. And we go on. There's an introduction from Simon Clarke. If we could go over the page, please. I'll just read to you a few sections. So Simon says, "The problem I've got is that we're not allowed to see the report, but we are told that there are up to 30 offices where bugs have been identified, yeah? And we know that Hurst Lane is not one of the branches where there's been an identified bug." Still with us. And Gareth says, "Right. As I say, certainly I'm aware of 2 bugs. Firstly, is this something that has been done on Horizon, on the new Horizon system or the old system?" And Simon says it's Horizon Online. And Mr. Jenkins says, "Okay, right. So there is 2 bugs that we have declared to Second Sight in that sort of area. And we know exactly which branches are affected, and they wouldn't have any impact whatsoever on that part of what's going on. And I think we're confident that the audit trail that you are using for prosecution has not been compromised by those bugs." And then if we go over the page, please. Halfway down, you're introduced. So Simon says, "Where are we going from here? What's the questions I posed earlier? Sorry, I've got Martin Smith here with me as well. He's the solicitor in the case. So were you the solicitor in the Samra case, or was that a different case?"
I don't recall, I'm afraid. I remember what the Samra case was about, but I don't know whether I was a solicitor in it or not. It was a lady who was alleged to have been making multiple transactions using the debit cards of pensioners, suggesting the first transaction hadn't gone through and asking the pensioner to re-input their PIN number. So I do remember that, but I don't know if I was the solicitor or not.
Okay. And then he says, "I know Martin. Hi, Gareth. Hi. It's the Horizon system is functioning perfectly." Can you assist us with what you mean there? Is that the matter that you're questioning, whether it is functioning perfectly?
I really don't know what that is supposed to mean.
Simon then says, "This is the other point. Bugs have been identified in Horizon which call into question some of the aspects of the way in which it operates. That's a fair assessment, isn't it?" And Gareth says, "Yes." And then Simon says, "Yep, okay. How can we be sure that A, we have identified all of the bugs that there are, and B, that although Horizon has been demonstrated that to be fallible, that insofar as the case we are conducting is concerned, we can eliminate the possibility of error?" And then the response from Gareth is, "Right, I mean, clearly you can never say there are no more bugs in the system, but we've got to be careful about trying to say anything like that. But what we can show is that nothing has been found to show that there is a problem in the integrity of the audit trail, which is what has been used for your evidence." And Simon says, "So your view is that that if the defence were to suggest that there's a problem with Horizon, and therefore we can't rule out that there might be other problems with Horizon, what you say is, as far as you're concerned, the integrity of the system is intact. And he says, yes. Did you have concerns, real concerns, at this time, June 2013, about the reliability of the expert evidence that had been provided in court?
Mr. Clark certainly had some concerns at that point, because as part of our conversations within Cartwright King, I provided him with a number of reports that Mr. Jenkins had prepared at Cartwright King's request. And obviously there had been a discussion about that. So yes, there was a concern at that point within Cartwright King about the evidence given by Mr. Jenkins.
You've seen there, I mean, you're having a conversation with the man who's given evidence in some of your cases. I mean, Ishaq case, Mr. Jenkins gave 2 statements.
Yes.
There's reference there to 2 particular bugs. There's reference there to you can never say that there are no more bugs. Did you personally not have a real concern about those cases that you were involved in?
I expressed concern to Mr. Clark that Mr. Jenkins had not raised those bugs during the currency of the case against Mr. Ishaq. In fact, I do recall that when Mr. Ishaq had suggested in his one of his defence statements that the losses were attributable to a freezing screen, I thought, my personal view was that he was suffering rather large losses attributable to a freezing screen. I thought, if anything, there was more to that. And I specifically asked Mr. Jenkins at court whether or not there had been a bug affecting Mr. Ishaq's branch, and he had said not. And so by the time we get to this point, yes, you are quite correct. I was concerned about Mr. Ishaq's case because Mr. Jenkins had said that there had not been a bug in his branch, and here we are now being told of 2 bugs by Mr. Jenkins. And I can recall discussing that with Mr. Clark, and I explained to him that Mr. Jenkins had said that there were no bugs operative in the branch, and that Mr. Ishaq had pleaded guilty. Mr. Clark's view was, well, that wasn't really to the point. Those bugs should have been disclosed to him.
And did you, at the time of recording that conversation, had you put 2 and 2 together at that point, that it wasn't just there were these bugs, but also that we have a problem with the expert that has given evidence in our cases?
Yes, that was discussed.
Was that information disclosed in ongoing criminal cases?
So far as the ongoing criminal cases were concerned, this all happened in a very, very short window. I believe that Susan Crichton and Simon Clark discussed the position and decided that it was appropriate, clearly in the circumstances, to impose a moratorium on all new prosecutions, so that there'd be nothing new entering the prosecution pipeline, and that in existing cases they would be reviewed by Mr. Clark, and depending on the nature of the case, it may be appropriate to terminate it in the absence of a new expert.
Was there not a real sense of urgency at that point, having found out that information?
Well, I think all this happened within a couple of days.
I mean, Mr. Clark's advice was only on the 15th of July, so a couple of weeks later. you had been involved in the Ishaq case, a man had gone to prison. Did you not think then and there, I've got to do something urgent about the cases that I was personally involved in?
I do recall expressing my absolute... I was actually quite upset about the position that there had been bugs which hadn't been disclosed in Mr. Ishaq's case. And I remember actually feeling quite angry about that because a man had gone to prison and quite frankly those bugs should have been disclosed. I asked Simon to review the case as a matter of urgency, and I believe that he did within the next day or so. I certainly have it in mind that it was reviewed very quickly.
Why did you need Simon Clarke to review the case? Why couldn't you, who had conduct of the case, then and there, do something about your anger?
Well, I just thought it was appropriate to have a senior barrister dealing with it.
Can we please look at poll 00060572? We're now on the 30th of June. John L. Singh is passing on information to various colleagues at the post office. And if we scroll down, he refers there to the case of Ishaq at the top. He then refers to the Dixon case. And he says, it follows that in some cases the integrity of the Horizon system has been challenged by the defendant. In other cases, the integrity of the Horizon system may become an issue, notwithstanding that there has been no specific challenge. And he then says, the Samra case above in Birmingham involves Horizon, so that's the case that you were talking about.
Yes.
With Gareth Jenkins. Samra is accused of performing unauthorised transactions on the post office's current account of a number of vulnerable people. She has consistently denied any wrongdoing, and the primary evidence against her is taken from the Horizon system. And it's this paragraph next that I want to ask you about. It says, Simon Clarke, Prosecution Counsel, and Martin Smith spoke to Gareth Jenkins on Friday the 28th of June. He told them that he had only volunteered information about 2 bugs present in the system to Second Sight. He also told them that those bugs would not have affected the integrity of the data being used in the Samra prosecution. If I may speculate a little here, Gareth Jenkins only told Second Sight of 2 bugs. The post office only knew of 2 bugs. It seems, therefore, unlikely they would find other bugs without Gareth Jenkins knowing about it, due to the mechanics of the system, reporting and the checks and balances already built into the system. It looks likely that Second Sight's report will focus on these 2 bugs. Just pausing there, do you think that is a fair reflection of the conversation that you had with Gareth Jenkins on the 28th of June?
Well, no, it isn't, is it?
One thing it doesn't suggest is, for example, the unreliability of Gareth Jenkins and the evidence that he has given.
No.
It also doesn't refer to that paragraph we saw about never saying that there aren't more bugs in the system.
No, and it's also confusing in that well, I don't really think I necessarily follow this. If I may speculate a little here, Gareth Jenkins only told Second Sight of 2 bugs. The post office only knew of 2 bugs. That's contradictory to the information he told me, and it says it seems therefore unlikely they would find any other bugs. Well, I don't know where he's got that from, because that certainly wasn't discussed with Gareth Jenkins on the 28th of June.
So the question that arises from that is, did you provide John L. Singh with the level of detail relating to the problems that Gareth Jenkins had told you about, or not?
We would certainly have communicated with Mr. Singh and kept him informed of developments. I mean, after all, he was head of criminal law.
and your real concerns about the reliability of Gareth Jenkins, had you by then, the 30th of June, passed those on? Because there's no mention in that paragraph, summarises the conversation but doesn't mention issues about the reliability of evidence. Do you think that you did or didn't pass that on to Mr. Singh?
I cannot recall what I said to Mr. Singh.
It then continues, it's not possible to ignore the fact that Second Sight may report in the immediate future. Similarly, it's not possible to ignore the fact that there may be high-profile debates relating to the integrity of the Horizon system this coming week. Prosecution counsel proposes to mention the position in private to the judge in the Samra case in his chambers on Monday morning. The Post Office, as a public body, has to be open and honest for the judge to ensure fairness to elderly witnesses, prosecution and defendants whose liberty is at stake. Why mention it to the judge in private?
I was being guided entirely by Mr. Clark in relation to this, and he was prosecuting counsel in that particular case, and he advised as to the best way forwards in relation to this particular issue that had arisen. I mean,
when the expression in private is used, do I take it that that simply means without the public being present? It doesn't mean without the defendant's representatives being present.
I believe, sir, that it was without the public being present and without the defendant's representatives being present.
I see. So this really was just prosecuting counsel and judge. That was what was being suggested.
I accompanied Mr. Clark, sir, to Birmingham. We went into chambers. I believe the mention hearing was recorded, and Mr. Clark explained to the judge from memory that there was a report which he was not yet in a position to disclose, but which would be disclosable, and given the imminency of Mrs. Samra's trial, he was in some difficulties.
All right. Sorry, Mr. Blake, for jumping in.
Not at all. Why not mention that in open court?
That's a question I'm afraid you'll have to ask Mr. Clark. I was guided by his advice. I mean, if I can put this in a different way, basically my whole career I'd spent dealing with defence work. I had then started dealing with prosecution cases on an agency basis, appearing in court for particular hearings and then reporting back. And then this was effectively a new chapter of work actually dealing with prosecution cases and advising in relation to them. And quite frankly, I was grateful for any guidance that I could get internally within Cartwright King. And this was Mr. Clark's advice, and so that's what he did, and I went with him to the hearing.
You had worked for Cartwright King for 6 years by this stage.
Yes.
Was the training so inadequate that you had to rely on Mr. Clark in this respect?
Well, I was quite well. There had been no training in terms of prosecution work at all, no training at all that for example, a CPS lawyer might get internally at the Crown Prosecution Service. We'd been on no courses. And I think also the perception of the firm was that it would be more appropriate, so far as Post Office were concerned, to see a senior, experienced barrister advising, one who had had much experience of both prosecution and defence work. So he was the one who took the lead.
A reading of this is that it would suit the Post Office because it wouldn't be publicised. Did you understand that to be the position?
Well, no, I didn't. And in fact, when we had the conference with Brian Altman KC, he was very clear that he would not have dropped the Samra case. He said that he wouldn't have dropped that, and I understood Mr. Clark's position to be not one of unwilling to make the disclosure, because quite frankly the second site report was, well, it's the interim report we're talking about. The interim report was always going to end up in the public domain. It was always going to be published, it was always going to be made public, and it was going to be disclosed in other cases. The fact here is not a case of trying to prevent that report from being provided. It was going to be provided through other routes. As I understood it, Mr. Clark's concern was that he could not comply with his duties of disclosure at that point in time.
Or even mention it in a public hearing.
I think there was a concern that it had been arranged by Parliament or organised by Parliament and parliamentary privilege attached to it. I remember a conversation along those lines, and he was quite clearly unwilling to say very much about it.
Is that a conversation with Simon Clark?
I believe it was.
So your understanding is that he had a concern about parliamentary privilege?
Well, we thought that the report had been commissioned by Parliament, or there was some connection with Parliament, because as we understood it, the second site interim report was to be released to MPs probably the day prior to publication. And so Mr. Clark did not feel it appropriate to start releasing any information from it, or I don't know whether we had the report at the point of the application, or just a part of it, or just information in about what it contained. Well, Mr. Clark's view, as far as I remember, was that it would not be appropriate to start putting into the public domain information which we either didn't properly have or couldn't provide when it was yet to go to MPs the day before publication.
Do you think that there was email correspondence on that issue?
Well, certainly not between myself and Mr. Clark, no. As I see it, this was a case of Mr. Clark saying we cannot comply with our disclosure obligations at the present time in relation to this imminent case. This was a case which involved, as it says here, a fraud, if you like, involving numerous elderly people who had had their cash cards used twice to their knowledge, well, without their knowledge, once with their knowledge and once without. One possibility was to seek an adjournment. That adjournment would be likely to be quite some time, and of course one would have to consider the effect of an adjournment on a decreasing number of victims because of their vulnerability and age. And so this was never a case, in my view, of not wanting to disclose the second site interim report. As I say, that was always going to end up in the public domain via one route or another. This was a case of Mr. Clark saying, I cannot deal with my disclosure duties here and now at this particular point in time.
It's also, I can't tell anybody that it even exists.
Well, we told Mr. Clark
Apart from the
explained the position in chambers to the judge, and I understand that if I remember correctly, that application was recorded.
Can we please have a look at poll 00190843? Actually, sorry, if we could start with poll 00190842. And this is an email from Hugh Flemington to yourself, and he says, please find attached a first rough draft from second sight of one half of the interim report. This will be supplemented tomorrow by a section on spot reviews. Please would you let us have you material and significant concerns on this first thing tomorrow morning, please. If this timing is not possible, please shout as soon as possible. And we see there the attachment is the interim report version 18A. If we look at poll 00190843, so this is the 4th of July, and this is the version 18A that was attached to that email. If we could look, please, at page 6. Page 6, 6.4, 6.5, 6.6, these are the receipts and payments mismatch and local suspense account bugs that we'll see in the final version of the second site interim report. And if we scroll down, we can see various other concerns that are raised relating to the Horizon system over the page, please, under thematic or systemic issues. Various issues that have been reported by sub-postmasters. That was the 4th that you received that draft. And then can we please look at poll 001908559. This is the next day, first thing in the morning, 8:59 in the morning. An email from yourself thanking Hugh Flemington for the report. And you say, our advice overall with regard to disclosure has not changed. The disclosure of a partial report would not meet our duties or help the current situation. I think the disclosure of a partial report would provide partial information and give rise to adverse publicity and speculation. It would be far better to advise once we have seen the entire report. Having said that, the second site report would not need to be disclosed in every case. The decision would need to be taken on a case-by-case basis. In many cases, it will not be disclosable. I just want to break that down into two. First is give rise to adverse publicity and speculation. I mean, isn't that exactly the concern that I was raising in relation to the private hearing before the judge? That is, on your part and on Cartwright King's part, a concern about adverse publicity.
No, the hearing before the judge was nothing to do with adverse publicity because, as I said earlier, the second site interim report, or the draft version of it, was always going to end up in the public domain. That application was made because Mr. Clark was concerned that he could not properly discharge his disclosure duties. And clearly, this is an email that both myself and Mr. Clark have put together because, as you'll see next to the yellow square that's on the left-hand side, it's our advice overall. This is very much the stance of Cartwright King, myself and Simon Clark having discussed the position.
Yes. The concern that I mentioned in relation to the hearing before the judge is a concern to have it in private, not about what would be said, but the concern about adverse publicity. Did you not recognise that that might be a concern?
Not in relation to that hearing, no. I just assumed that was the correct way to go about things because that was what Mr. Clark advised.
And sticking with this email, is your advice relating to adverse publicity and speculation, is that similar to where we started today, a confusion between the post office's private interests and legal requirements?
No, I don't think it is. I think the danger with disclosing a partial report is that you're only disclosing part of the picture. Isn't it best to see the entire report and then make decisions?
But why should publicity be a concern of somebody who's advising in criminal prosecutions?
I think this... Sorry, can you just scroll up? What's the date of this email?
The 5th of July.
So this would follow a meeting which had taken place at the headquarters of Post Office Limited, which at that point were an old street in London. And I think at that point, Post Office was expressing concern that there could be adverse publicity and keen to avoid speculation.
So it was the Post Office rather than...
So I think this is going back to the concerns which would have been raised at that meeting. So I think our approach to this would have been that it would be better to await the full report and then make decisions rather than start to disclose bits of a report and have adverse publicity and speculation in relation to the gaps.
And then having said that, the second site report would not need to be disclosed in every case. That decision would be taken on a case-by-case basis. In many cases, it will not be disclosable. Is that right?
I think where we were at the time, that was our thinking.
I mean, you had had that conversation with Gareth Jenkins where he said there might be more bugs that caused you real concerns about the evidence that he had given in criminal prosecutions and his reliability. Do you think that such a strong line could really be taken?
Well, if you look at the file review process that was subsequently undertaken, I think out of the total number of cases which were reviewed, the second site interim report was disclosed in a proportion of them. So I think the view that we took within Cartwright King at the time is that it certainly wouldn't need to be disclosed in every case, but depending on what it contained, a decision would have to be taken on a case-by-case basis. And
that is absolutely an issue that we're going to be coming to in due course. Can we please look at poll 00297-237, please? Just to assist us with the timeline, in fact, it was the very same day, an hour later, that you received the full report, full draft report
right.
Still, so that would have been the second half relating to spot reviews. We can see there Ian Henderson at the bottom is sending the latest version, version 24 of the draft report. And if we see at the top, Roderick Williams has sent it on to you. Can we please now look at poll 00006545 and page 4. The bottom of page 3 onto page 4, please. We have an email from yourself to Hugh Flemington, and you say, "Dear Hugh, please find attached a copy of the letter which we propose, subject to your agreement, to send to Ishaq solicitor." So this is the 10th of July. I think your evidence before was that quite promptly you did write to Ishaq's solicitors, and this is that correspondence.
Yes, I couldn't remember how promptly, but it certainly predated the file review process.
Yes.
I think I was so concerned about Mr. Ishaq's case that I actually circumvented the sifting process. I didn't see the point in putting it through a sift. I knew it needed to be reviewed, and I brought it to Mr. Clark's attention for it to be reviewed. So this was something that was dealt with, if you like, outside of that the main file review process.
Can we please look at the draft letter? It's poll 00323836. So in April 2013, he had been sent to prison. This is a letter in July now. I'm going to read to you that letter. It says, "We write to your firm as being the solicitors on the file representing this defendant in the proceedings, which resulted in him receiving a term of 54 weeks imprisonment for an offence of theft. On the 8th of July, a report into the operations of the Horizon system was published by an independent organisation which had been commissioned by our clients, Post Office Limited. The report is known as the Second Site Interim Report. We have also received and considered a second report concerning an investigation into an incident at another post office, the Helen Rose report. We have thoroughly reviewed both the prosecution case and that of your client, and in particular his defence statement and addendum defence statement in the light of material contained within the Second Sight interim report and the Helen Rose report. We have also reconsidered our disclosure duties under the Criminal Procedure and Investigations Act 1996 and the Code of Practice enacted thereunder and the Attorney General's guidelines on disclosure. We have formed the firm view that had the prosecution been possessed of the material contained within the two reports during the currency of the prosecution of your client, we should and would have disclosed that material to you in compliance with our disclosure duties. Over the page, please. Accordingly, we now disclose those reports to you so that you are able to consider whether your client may have grounds for an appeal against his conviction. We would also remind you of your duty not to disclose this material to any third party other than your client. In particular, the Helen Rose report is not in the public domain. So the proposal is to now disclose to Mr. Ishaq's solicitors the Second Sight interim report and the Helen Rose report. Is that right?
Yes.
No apology in this letter, correct?
There is no apology in that letter, no.
No reflection of any wrongdoing or concerns about material not being brought to Mr. Ishaq's attention that really should have. No apology for that.
No, the letter is as you've read it.
And it ends with no sharing allowed in relation to the Helen Rose report. Is that again a concern about the publicity that might raise?
I have I didn't consider that point. This is the letter as Mr. Clark prepared it.
If we could zoom out, please, just to look at the entirety of the text. Is there any reference in that letter to concerns about the reliability of Gareth Jenkins?
No, there isn't.
Do we find also attached the list of cases relating to Horizon concerns that had been prepared by Helen Rose back in October 2012?
No.
Why were the Second Sight report and the Helen Rose report considered to be sufficient?
At this point in time, I was unaware of the content of the spreadsheet and the first Helen Rose document. And these were the documents that we had been provided with.
We are also concerned about a witness in your case who was referred to as an expert witness who we believe gave unreliable evidence. Is that set out there?
No, it isn't.
Do you know why not?
I'm sorry, I can't answer that question. I don't know.
As somebody who was involved and a firm that was involved in the original prosecution, do you think Cartwright King were the right people to determine how much additional disclosure should now be provided to Mr. Ishaq?
At the time, yes, I did think it was appropriate. I remember Mr. Clark explaining around the 3rd of July meeting in London that it was not inappropriate for a prosecutor involved with a case to review the case to determine whether further disclosure ought to be made.
Can we please return to the email chain we saw just a moment ago, poll 0006545. We looked at the final entry in this chain, which was you sending this draft to the post office. Can we please start on page 3 this time? Roderick Williams sends you a response thanking you and says, first point, we presume that Helen Rose's report is being disclosed because the Post Office's evidence in the prosecution included an ARQ report. Is that right? Second point, Helen Rose's report is marked confidential and legally privileged. I understand that she did this because she prepared the report to give to Post Office Legal for legal advice on the implications of her investigation. Please therefore consider what information from the report needs to be disclosed to Ishaq's solicitors and in what format, i.e. whether parts of the report should be removed or redacted, or the non-privileged material repackaged for disclosure to the defence. If you advise that Helen's report does not attract any privilege, please ensure reference to privilege is removed. We'll look at the other email in the chain, but just pausing there, what was your impression of how open the Post Office were to providing disclosure to Mr. Ishaq at this time?
It's difficult to recall, but my impression was that they were content to follow Mr. Clark's advice.
If we turn to page 1, please. It's an email from yourself to Roderick Williams and others. Now, it looks there, I think it's an American format of the date. It should be the 11th of July. For those who are interested, we have another version of this. It's at poll 00323841. It doesn't need to be brought up on screen, but that shows it as 11th of July, which makes sense in terms of the sequencing.
Yes.
You're emailing Roderick Williams about privilege, and you then have a section why Helen Rose's report is disclosable, and you highlight features such as those that rather suggest that there may be horizon issues plus training and support deficits, and you highlight the reference there to horizon integrity issues and say this is an alarming statement, for it is suggestive of the existence of horizon issues and that they were known to Gareth Jenkins. This has obvious implications for Gareth Jenkins's court reports and appearances and his silence therein. And note that, as I say, was not referred to in your draft, and I think you accept that. If we scroll down, we see there, paragraph 3, you refer to Helen Rose's ultimate conclusion is that this is not an issue which suggests a failing in Horizon itself, rather it's an issue of data presentation. Whilst to a degree that is correct, given what I have said in 1 and 2 above, that view may not be entirely sustainable. It may be suggested that the report is at the very least suggestive of horizon issues. And then you go on to say, the report in general terms reinforces the impression that Gareth Jenkins is not being entirely forthcoming about horizon issues. An example of this approach may be found within his response to Helen Rose's first question, where she asks, also, could you explain what happens when the system fails? Gareth Jenkins does not begin to answer this question. He simply responds, the system is behaving as it should. If the system is behaving as it should, then the answers I reproduce in my point 1 above are inexplicable. 5, some may conclude from this that Gareth Jenkins' aim is to protect Horizon from criticism rather than to provide the Post Office and the court with impartial and honest evidence. In view of these matters, I think that the information contained in the Helen Rose report meets the test for disclosure. It should not be forgotten, however, that information would only meet the test in a limited number of cases, i.e. those where the defendant had conducted reversals and was blaming Horizon. Just pausing there, is that right? I mean, again, we're seeing an email from yourself that is narrowing the number of cases in which this needs to be disclosed.
Well, you say it's from myself and Simon, as you'll see how it's signed off.
Yes.
This is a joint effort, and I'm clearly taking advice from Mr. Clark.
I mean, sent by you.
It's sent by me, but if you have a look at the screen at the moment under kind regards, it's Martin and Simon.
Yes.
So this is clearly a joint piece of work.
Does that make it any less troubling?
What it means that I am clearly taking advice from a senior in-house barrister about the position.
It then says, accordingly, you may take the view that I should attempt to... in view of the matters, I'm in no doubt... In fact, it says I there rather than we, but...
It does.
We can put that to one side. That this document is disclosable. On the LPP point, I rather fear that if the matter were to come before a criminal court, the judge would, without hesitation, order disclosure in the appropriate case. Accordingly, you may take the view that I should attempt to redact or summarise the report into a disclosable document and in a form which serves a dual purpose of both disclosing that which should be disclosed whilst protecting the non-disclosable sensitive material. Well, first of all, by this date, it seems as though you are getting quite concerned about how candid the post office have been. Is that a fair summary of the contents of that?
Well, this Helen Rose report has clearly now arrived, and it's in addition to the 2 bugs referred to in the second site interim report. So there is another report to deal with. I don't think I gave it much more thought. I can recall that it was Mr. Clark who then went on to redact the Helen Rose report before it was sent out. And it was Mr. Clark who then drafted the letter to be sent out to the intended recipients.
At paragraph 14 on page 5 of your second statement, you very candidly say that you are unaware of the post-conviction duty of disclosure. Is that correct?
Yes, I wasn't aware of that.
I mean, wasn't that precisely what you were being asked to do by Roderick Williams, to consider such duties?
I became aware of the post-conviction duty of disclosure upon discussing Mr. Ishaq's case with Mr. Clark, because I pointed out that Mr. Jenkins had said that there had been no bugs in the branch, and Mr. Clark's view was that, well, this is still disclosable because it would give Mr. Ishaq the opportunity to argue that there were perhaps bugs as yet unknown to Post Office, and therefore this should be disclosed. I had not been in this situation before, needing to consider post-conviction disclosure. I was simply unaware of that.
Is that of concern, given that you had been involved in quite a few criminal prosecutions for a number of years by that stage?
Well, everything was going to be reviewed, wasn't it? That was the point. We were then going to review things.
But was it of concern that you, a person who had conduct of cases, a solicitor who had conduct of cases, wasn't aware of the test for disclosure once people had been convicted?
I didn't see it as a concern. I regard it as professional development.
Do you see it as a concern now that you weren't aware of that test?
I do, yes.
Thank you. So that might be an appropriate moment to take our mid-afternoon break. If we could come back at 25 past, please.
Yes, certainly. Just before we go, though, and stop me, Mr. Blake, if you're going to continue to pursue this, but I'm still baffled about how it can be, Mr. Smith, that you quite rightly take the view that the Helen Rose report and the second site report should be disclosed. But there doesn't appear to be any consideration at all about the disclosure of your discoveries relating to Mr. Jenkins, if I can put it in that way. Because in particular in relation to the Helen Rose report, but really in relation to both, all of those matters are inextricably linked, are they not?
I cannot recall, sir, any discussion within the office about disclosing information with regard to the position with regard to Mr. Jenkins. I don't recall that being discussed at that point, or indeed.
But that in itself is, let's just say, surprising, is it not? Because you have your conversation with Mr. Jenkins on the 28th of June. That immediately raises alarm bells, one would imagine. And I think that's the purport of your evidence. We then get sequentially Second Sight and Helen Rose in quick succession, literally within a short number of weeks from the discussion with Mr. Jenkins. And on the 15th of July, Mr. Clark actually puts in writing, in unequivocal terms, his very many misgivings about Mr. Jenkins. So it does seem very odd that this isn't a topic of discussion, in particular in relation to what you're going to do about Mr. Ishaq, who may or may not still have been in prison at that point. Anyway, there we are.
Well,
25+2.
Oh.
3, sorry.
So I think Mr. May just answer.
So would you like me to revisit that after the break?
Yeah, by all means. Think about it.
Well, I can answer it now, but I'm aware
Right.
that
Go
we're
on,
about to have
yeah.
a break.
Yeah, go on. We'll extend the break till 3:30. You answer it.
Okay, thank you. So there was literally no discussion, as I recall, about disclosing information about Mr. Jenkins, and when we subsequently went to see Brian Altman, KC, to discuss the file review process and the letters which were being sent to others with regard to post-conviction disclosure, I don't recall it being mentioned then. I don't recall it being suggested that a paragraph should be inserted to deal with Mr. Jenkins.
Well, no doubt that is an issue that will be taken up sequentially with the lawyers who come after you, Mr. Smith. Thank you.
Thank you, sir. past. Thank you, sir. Moving on to the Criminal Cases Review Commission, can we please look at poll 00039994? They send a letter on the 12th of July 2013, so the same time period as the documents we've just been looking at, around the same time as that letter was being drafted to Mr. Ishaq. If we scroll down, please, it's sent to Paula Venables. And it says, for obvious reasons, we have read the recent media coverage concerning the Post Office Horizon computer system with interest. Clearly, it would be very useful for us to have more information directly from the Post Office, especially accurate information as to the number of criminal convictions that might be impacted by the issue and what action is proposed or being taken in that respect. So this is in following the publicity relating to the Second Sight interim report.
Yes.
Could we please turn to poll 00039998? Do you recall as a firm being tasked to draft a response to the letter?
I think we were. Well, it would appear that we were, but I don't recall it.
We have here an email from yourself to
Yes.
Susan Crichton. Susan, please find attached documents prepared by Simon in response to the letter from the CCRC. And if we scroll down, we can see Simon Clark. Herewith, my response to the CCRC letter. The PDF is simply a brief discussion of CCRC's criteria. The Word doc is a draft response for poll if they think it may assist. Do you recall it, if this was something simply volunteered by yourself and Mr. Clark, or whether it was something that was specifically requested by Susan Crichton, or something else?
I'm afraid I can't remember.
Could we look at the first document that was attached, and that's poll 00039998? Sorry, poll 00039993. Do you recall seeing this document? This was attached to that email that you sent to Susan Crichton.
I don't know whether I considered it in any depth.
Do you recall why this was prepared?
I would imagine that Mr. Clark was simply providing information at the request of Post Office Limited and the legal department. But I can't recall having anything really to do with this apart from sending it on.
Can we look at the other attachment, and that's the draft response? It's poll 00039995. These are the draft paragraphs for insertion into the reply. I'll just read to you a few sections from this. The second paragraph, halfway through, it says, the detection and successful prosecution of such offences is almost always dependent upon a proper analysis and presentation of Horizon data, and accordingly it's imperative that the integrity and operation of the Horizon system is demonstrably robust. In many prosecutions, the defence will fall into one or more of the following categories, and then a number of categories are identified. And then it says as follows. It says, where a defendant asserts, rightly or wrongly, that Horizon is at fault, it is for the prosecution to demonstrate the integrity of the system and the evidential audit trail derived from Horizon. Just pausing there, is that the approach that you think the Post Office took over the years, that it's for the prosecution to demonstrate the integrity of Horizon, or do you think from what we've seen already today that there was a fair bit of a burden put on the defendants themselves to particularise their complaints?
No, as I've said in my statement, my second statement, the approach taken by Cartwright King was not to obtain a report in every case where there was a suggestion that the Horizon system might be at fault or someone explained loss. The approach taken by the firm was a sort of wait and see approach, and if the defendant didn't plead guilty, then a report would then be sought, which of course is something very different.
It then says this is usually accomplished by the serving of expert evidence. For many years, both the Royal Mail Group and latterly the Post Office has relied upon a single expert witness provided by Fujitsu Services Limited, the Horizon manufacturer, maintenance and support contractor. That witness has provided expert evidence in many cases where the defendant has asserted irregularities with Horizon to be the cause of unexplained shortfalls. As to the operation and integrity of the Horizon system, he has done so both to the Post Office and in expert witness statements and oral evidence to the court. In particular, he has attested to the presence of defect detection and rectification systems, the robustness of the prosecution audit trail, and stated that, in his expert opinion, Horizon accurately records and processes all information submitted into the system. The second site interim report demonstrates that this was not the case. What isn't mentioned there is your real concerns about the reliability of Mr. Jenkins' evidence. Is that?
No, there doesn't appear to be anything there about that.
No. If we continue, I mean, Simon Clarke's advice on the reliability of Mr. Jenkins was the 15th of July, so the day before this draft was produced. Do you think it is surprising that this letter to the Criminal Cases Review Commission was not phrased with similar concerns about Mr. Jenkins' reliability?
At the time, I don't think I gave it any thought. But looking back, I take the view it should have contained information relating to Mr. Jenkins.
Actions taken by the Post Office. The Post Office accepts that a number of criminal convictions may be impacted by the matters highlighted in the second site interim report and has taken early and determined steps to identify those cases where such an impact may fall. So there's mention of second site here, but there isn't mention of the Helen Rose report either, is there?
No, there doesn't appear to be.
And then the next paragraph, to that end, the Post Office has instructed an independent firm of criminal specialist solicitors to identify every criminal case prosecuted by the Post Office and Royal Mail Group prior to their separation, and in any event in the last 3 years, so as to determine, in each case, the answer to that question. Instructed an independent firm of criminal specialists. Is that correct?
That would be Cartwright King.
And having prosecuted a number of those cases, do you think it's fair to describe Cartwright King to the CCRC as an independent firm of criminal specialist solicitors?
Well, I guess the answer to that is we were independent of Post Office, so we weren't within Post Office's legal team, and we were external to Post Office. But of course, we weren't independent of the actual prosecutions because we had conducted a number of them.
If we could go over the page to page 3, please. If we scroll down, number of impacted cases, it says, where counsel has advised the possibility of grounds to appeal, letters have been written to solicitors who defended, informing them of the issues and providing copies of the second site interim report and such other material as they ought to have received during the currency of the prosecution, had we then been possessed of that material. It would then be for the defendant and his lawyers to determine whether or not they wish to launch an application for leave to appeal out of time. We would certainly support grounds to allow the application out of time. Again, reference there to the second site interim report, but no mention of Helen Rose report or any other specific information set out there in that draft letter. Is that correct?
Yes, I also think, looking at that paragraph, it's saying letters have been written to solicitors who defended. I'm not sure the letters went out that promptly.
And it concludes, thus far, the review has identified no cases where the defendant has sought the leave of the Court of Appeal to appeal against his conviction. One case has been identified where the defendant sought and was refused leave to appeal against his sentence. Sorry, if we go over the page, please. We then have Magistrates' Courts convictions, a section on that, and it's the final passages of this draft that I want to now ask you about. It says, we take the view that it is incumbent upon the Post Office as a major public institution to take every reasonable step to ensure that only the genuinely guilty are convicted and that those who are or may have been convicted without good reason have every opportunity of correcting such a miscarriage of justice. Do you think that that fairly reflects the very narrow approach that seems to be taken to disclosure of matters that are well known by this stage to the Post Office?
Well, at this point in time, there were very few matters known. There was simply the 2 bugs and the Helen Rose issue. The Helen Rose report, in my mind. So
you had sent this draft, it seems to be authored by Mr. Clark, but you had sent it to the Post Office.
Yes.
Presumably you read it before you sent it.
I don't know whether I did or not.
Would it be typical of you just to forward things to the Post Office, or would you consider matters such as a response to the Criminal Cases Review Commission relating to cases that you have prosecuted?
No, if Mr. Clark had drafted something, I would have trusted him and forwarded it.
you are sending a letter to the post office which makes absolutely no mention of the kinds of concerns that the post office had at that stage about Mr. Jenkins, within days of Mr. Clark's actual advice on the impact of Gareth Jenkins' evidence, and it isn't mentioned. Do you think that that is of some concern about how open and transparent your firm intended to be with the Criminal Cases Review Commission?
I don't believe I gave that any thought at the time. It seems to me that I've simply forwarded documents.
Can we please look at poll 0013970? So you were simply forwarding documents on the 16th of July relating to the Criminal Cases Review Commission. We're now a few days on, 19th of July. You're attending what is called a regular call regarding Horizon issues. Is this the first of those meetings?
I believe it was, yes.
And it then became a regular call relating to Horizon issues?
Yes, they were weekly to start with, and then at some point in the future they became fortnightly.
If we scroll down, please. Rob King, who's a member of the security team, says as follows, the note is as follows, no minutes circulated, but we will be taking notes. So it seems as though there is some sort of direction that no minutes from these meetings will be circulated. Is that something you recall?
Well, I've dealt with this in my witness statement. I recall that one of the civil lawyers from Bond Dickinson explained virtually straight away after Mr. King had spoken the reason for this, and he was clearly talking from a disclosure position in civil cases. He said that he'd had previous experience of this and that he was concerned that if minutes are circulated by email, they then can be forwarded on to other people, potentially well-intentioned, with a view to getting opinions that might generate incorrect information. It might generate opinions that are incorrect, and it can result in information being stored elsewhere away from the call. And so whilst he was concerned about that, I considered that from a criminal perspective. In London, at the meeting, Simon Clark had been very careful to advise the legal department of Post Office what their obligations were and what their duties were from a criminal disclosure point of view, and that a central hub should be set up to collate information. And I could see from what Mr. Parsons was saying, from Andrew Parsons' concerns, that there was a real chance, if he was concerned about that, then I was equally concerned that we could be faced with a situation where there could be several mini-hubs of information containing various amounts of information which might or might not be correct, and going forwards that would make a disclosure exercise very, very difficult, and also difficult to instruct a new expert if there are different hubs of information. So I understood the rationale for that.
Let's see where you're mentioned. If we scroll down, it has your name in the next box. And it says, confirmed it was good Horizon wasn't discussed at length during interviews under caution, and also the use of template statement. Would like to be appraised of developments regarding interviewing and to have sight of statements and scripts. And then it says this, it says, clarification on disclosure and email correspondence, emphasise need to ensure that any document produced would be potentially disclosable. So is that you there emphasising that any such document that was produced would be potentially disclosable?
Well, I don't think this is correct. I believe that I spoke towards the end of the call, not at the beginning. It was Mr. Parsons who spoke after Rob King. He was concerned about inaccurate information being generated, and when I spoke, I explained that any information generated obviously needed to be accurate and kept, because it may well be disclosable.
We see there are two entries from Mr. Parsons. The first one It says as follows: commented on the need to limit public debate on the Horizon issue, as this may have a detrimental impact on future litigation. And if we scroll down over the page to page 3, near the bottom of page 3, the third entry from the bottom, we see another entry summarising something that he is said to have said, which is spoke about emails, written communications, etc. If it's produced, then it's available for disclosure. If it's not, then technically it isn't. What did you understand by that?
Well, I understood him to be talking about pre-action disclosure in civil cases, nothing to do with criminal litigation and criminal law. Post Office had already been advised from a criminal perspective quite thoroughly by Simon Clarke. They'd accepted that advice, they'd set up this call, and he was a civil lawyer on the call, clearly not offering criminal law advice because he's not a criminal lawyer, but clearly looking at the position from a civil law perspective. He spoke at the outset of the call about his experience in previous cases where he'd had nasty surprises when he'd done trawls of emails and found information that I think was incorrect or something like that. So clearly what he's saying there is basically a warning, because if people aren't committing things recklessly to paper, or if they're not recklessly writing emails, then it obviously makes his job easier.
What about the first one, page 2 in the middle, commented on need to limit public debate on the Horizon issues, as this may have a detrimental impact on future litigation? I mean, was the advice that was being given, if not by you, then by Mr. Parsons at this meeting, one of limiting what is said about Horizon issues?
I don't recall the meeting, and I generally made copious notes, which I left at Cartwright King. My understanding was that he was concerned about incorrect information being discovered on email trawls, then going into the public domain through pre-action disclosure. And of course, if people have been guessing or speculating or coming up with incorrect points, well, I guess his point was that's equally disclosable in a civil case and could cause damage to Post Office.
What's noted here, though, is much wider than that, isn't it?
It is need to limit public debate. I don't recall that.
And if we scroll up the first page, Rob King, no minutes to be circulated. I mean, that must have been of concern, mustn't it?
Well, it would have been had Mr. Parsons then not explained his rationale for that.
I mean, let's just look back at everything that we've discussed so far today. You were involved in the criminal prosecution on behalf of the Post Office in a number of cases,
yes.
Correct? You prosecuted people, resulting in some cases going to prison, certainly Mr. Ishaq's, correct?
Yes.
Yes. Irrespective of your knowledge at the time you were prosecuting, you have by now found out that there was a lot more information about bugs, errors and defects in the Horizon system than you knew at the time. Is that right?
Well, at this point in time, we have knowledge of the Helen Rose report and the second site draft interim report.
Yes, and you've also learned about concerns that an expert witness who had been giving evidence in your prosecutions knew a lot more than had come out in evidence about bugs, errors and defects.
Yes.
You read the Helen Rose report by this stage, correct?
I believe so, yes.
You've been sent a draft response to the Criminal Cases Review Commission, which makes no mention of a number of those matters. Is that right?
Yes.
And now there seems to be a discussion about limiting the amount of information in the public domain. Does that not cause you real concern at this stage?
Well, no, it didn't, because Mr. Clarke had advised that there be a central record, and as I understood it, a central record was going to be created. That was the purpose of this call. And quite frankly, I was content for there to be a single central record, not several central records.
But why no minutes circulated?
Well, as I say, that had already been explained, because people then can forward them on, and that could then attract other opinion, get forwarded on to others. And I think it was described as a sort of spider effect, where it can crawl and you don't know where the emails end up, and you don't know what's been added to them.
So was the purpose of the central store not to make sure that everybody had access to central material, but to keep everything away from being distributed?
Well, no, that's the purpose of the central store was to ensure that everything was collated in one place. That would be then interrogated for disclosure purposes, and it would also mean that instructing any new expert, there is only one single central store be sent to that expert. And as I understood this, if there were applications for pre-action disclosure, and I don't know that much about civil litigation, but again, there's a single central store for that. I think the point that we had in mind was that it would actually serve both camps if there is one single central store. The minute that you start having emails being circulated with people then being able to add to those email chains in a way that wasn't visible to the central store, the minute you start to not have full visibility of the issues which perhaps ought to be recorded in the central store. So at that point in time, I was not actually concerned about that.
Can we then look at document retention and destruction post 19th of July? And can we look at poll 0013975, please? This is a discussion that took place on the 1st of August 2013. Is this your note?
Yes.
Yes.
My details are in the top right-hand corner, yes.
So it seems as though you had a telephone call with John Scott on the 31st of July 2013. Is that correct?
No, that's not correct.
When did you have a discussion with John Scott?
It wasn't a telephone call with John Scott. JS here would be John L. Singh. So this was a note that I made on electronic file 37142 on the 1st of August 2013 relating to a telephone call that had taken place at approximately 6 p.m. the night before the 31st of July. And as you'll see here, the summary cuts off, but there's more detail in the lower section. J. Scott has instructed that the typed minutes be scrapped. There was obviously a lot more to that call because, as you can see from the time recording at the bottom, I was engaged on that call for some 24 minutes.
It's a summary that's there. It's very important for this inquiry to know what you recall about that discussion and the words used. Can you assist us?
I think I've put this in my second, both witness statements, because I could see in my first witness statement this was something that was going to be of relevance. I was actually driving at the time when I took the call from Mr. Singh, and I can recall complaining to him about the influence being exerted over Post Office, in my view, by the civil lawyers, the external civil lawyers. And I can also recall him telling me that an instruction had been sent out, and that if anyone that the type minutes should be scrapped, and that if anyone asks, then Cartwright King would be blamed for providing that advice, or words to that effect. I can recall being absolutely horrified and shocked by what I'd heard. And when I had the opportunity to pull over, I was able to use another mobile telephone to record at a distance the latter part of the conversation, because I was just so shocked by what I'd heard. I can recall relaying that to Mr. Clark. I'm afraid I can't really recall much more about precisely what was said, but I remember that I relayed to Mr. Clark the concerns that Mr. Singh had, that I had, and the comments made. From memory, this was just after the third Wednesday morning call. So there'd been a space of about a fortnight since the first call. No minutes were being circulated. And I can remember saying to Mr. Singh, I can appreciate the reasons for that, and quite frankly, that actually wasn't necessarily a bad thing from a criminal law perspective if it meant that there was a single central store which was accurate. It made our life much easier to just go to one place rather than having to wonder if there was information in several places. The same approach was adopted on the second call, but I can recall by the third call there was some form of change proposed. I don't remember, I'm afraid, exactly what the change was, but I do remember saying on the call, no, hold on, you still have to keep a central record, and making the decision that I would ask Mr. Clark to prepare a formal advice to Post Office so that it put absolutely in black and white their obligations and confirming effectively what he had told them at the very first meeting, the advice that they had accepted and acted upon to set up that Wednesday morning call. And I was actually concerned that Post Office had accepted that advice and acted upon it, but in my mind it was the actions of the civil lawyers that were now trying to water that down and move away from that situation. And I'm afraid I took the view that must have been the actions of the civil lawyers having an influence there, because Post Office had accepted the advice that Mr. Clark had given to set up that call, to have a central hub. I took the view that they'd accepted that advice and were acting in good faith to do that, and therefore formed the view, rightly or wrongly, that it must have been then the function of the civil lawyers, the effect of the civil lawyers, who were then trying to pull away from having that central hub. And I considered that by the time we got to the third Wednesday morning call, to start having a position where we're not going to have anything in writing, that did worry me, that I was concerned about that. And then this conversation followed on very soon after that.
So let's break down that telephone call at 6 p.m. on the 31st. First of all, did Jarnail Singh tell you that this was on legal advice, or did you not have that conversation? You've said a number of times that it was the advice of the civil lawyers. Is that an assumption, or is that something you were told?
Sorry, that was the... no, I assumed when I was talking to Jarnail Singh that it was the advice of the civil lawyers to move away from having anything in writing. Because we'd gone from having a situation where minutes weren't going to be circulated, but a central record was going to be kept, notes were going to be kept. I was expecting some form of minutes or a spreadsheet or something that would be documenting the issues arising in accordance with Simon Clarke's advice, which had been accepted. So the second meeting took place. Again, there was the same sort of discussion at the beginning, but by the time of the third call, it was a case of there being some suggestion that we're not going to do things in this particular way anymore. I can't remember what it was, and
The words used here are scrapped. Now, is that, from your understanding of that telephone call, was it that notes or typed minutes were to be stopped, or were they to be destroyed?
to be destroyed?
And was that your clear understanding from that conversation?
Yes.
We know that in Mr. Clarke's advice, he uses the word shredded.
Yes.
Do you know where that came from?
I can only assume it's arising out of the conversation that I had with Mr. Singh.
And is that something you recall from your discussion with Mr. Singh?
Not at this point in time, no.
So you don't recall the specific word shredded, but you do recall that type minutes were to be destroyed rather than there was going to be some sort of stop in taking future.
No, that was very much my understanding, that Mr. Singh told me that the understanding that I had was that Mr. Singh told me that the minutes were to be destroyed. I can't remember the exact phraseology. I'm afraid
Were
it's
to
10
be
years ago.
or had been? There's a big difference between the two.
I was under the impression that the instruction had gone out and that they had been.
Instruction from who to who?
The information that I was given that it was Mr. Scott, John Scott, head of security, who had sent that instruction out. To whom I believe it was I'm hesitant here because there were a number of people with the name David, and I'm thinking it was either David Pardo or David Posnett, but I'm afraid I can't. It was a long time ago.
And did you understand that Mr. Scott had received advice in respect of that matter, or that he was acting on his own instigation?
I had no idea. I was concerned by that third Wednesday morning call that somehow there was a plan to change things. I didn't like that. And then...
what was it that happened at that Wednesday meeting call that was of significance?
I was left with a distinct impression that Post Office were no longer wanting to keep a record of the calls. And I can recall saying, no, you must still keep a central record.
And
I don't know
say
if you have
Post Office, who at the Post Office?
I think that was information that came from Roderick Williams. I think it was Roderick Williams who said that, because I think I said, Roderick, you still need to keep a central record. And I remember not being very happy about it and thinking, this is one for Simon Clarke.
And civil lawyers were present at that meeting. Did they have any input as far as you were aware?
I don't recall, I'm afraid. And I don't have my notes from those meetings.
I might just take you to one more document before we finish for the day. Can we please look at poll 001394746? This is an email from Jarnail Singh to yourself on the 1st of August, so the morning after.
Yes.
And he says, Martin, I know Simon is advising on disclosure, so it seems as though during your conversation there was a discussion that Simon would be advising.
Yes, I've told him that clearly the disclosure situation in criminal law is very different to that in civil litigation. A central record needs to be written, needs to be kept, and that's the position.
And it says, as discussed, can he look into the common myth that emails, written communications, etc., meetings, if it is not produced, it's then available for disclosure. If it's not, then technically it isn't. possibly true of civil cases, not criminal cases. I mean, those words there seem to reflect the minute that we saw
Yes.
Mr. Parsons, the words from him. What did you understand Mr. Singh's position to be, or what was he asking for here?
Well, I was a little puzzled when I received this because I'd already told him the previous night that we weren't getting involved in the civil litigation side of things, and whilst the civil lawyers may not want things in writing, it's the information that matters, and you have to have a central record.
And common myth.
Yeah. Well,
was that amongst the legal team or something else?
I have no idea where he got that from. Absolutely no idea. What I do know is that Mr. Parsons had been talking from a civil perspective, and I don't know whether Mr. Singh had been on that same page and assumed that was the position in criminal law too. But I remember pointing out to him on that phone call the previous night that I was actually getting quite concerned because Simon Clarke's advice had been accepted. It had been watered down slightly, but in a way that I could live with. And then, of course, there was now going to be a further change, which I was actually quite concerned about. And therefore, I was asking Simon to further advise.
Thank you. So that could be an appropriate time to stop. We've been going for a long time today.
Yeah, yes, indeed. So what's the programme tomorrow? We've got Mr. Ojar returning, yes?
We do. That should be for no more than an hour, I believe.
But is that happening first thing, or
Yes.
is he
So that will happen
happening first thing?
At 9:45, and then Mr. Smith will come
Then
straight
continue?
on. Yes.
Yeah, all right, fine. I'm sure, Mr. Smith, you know that you shouldn't discuss your evidence overnight, so please don't do that. And I'll see you in the morning, probably at around 10:45.
Thank you, sir.
And everyone else at 9:45. Thank you.
Thank you, sir.